Hello everyone, welcome to Indian Current Affairs podcast channel. Today we are going to discussing some of very important MCQs related to Indian polity. Let's start the first question. What was the key outcome of the Supreme Court's judgment in the state of Punjab versus Devendra Singh case on August 1st, 2024? So, outcome of State of Punjab versus Devendra Singh case. First one, the Supreme Court ruled that subclassification within the scheduled caste and scheduled tribes is unconstitutional. Statement B, the Supreme Court upheld the validity of subclassification within the scheduled caste and scheduled tribes categories. Option C, the Supreme Court ruled that the states do not have the power to create subclassifications within the scheduled caste and scheduled tribes. So, option D, the Supreme Court declared that the scheduled caste and scheduled tribes categories cannot be altered by state government. So, which is the outcome of the state of Punjab versus Devendra Singh case? So, answer to this one is the Supreme Court upheld the validity of subclassification within the scheduled caste and scheduled tribes categories. So, Supreme Court approved to divide the SC and ST categories. See next question. Consider the following statements. Governor may sanction initiating proceedings against the CM under Prevention of Corruption Act 1988 and the Bharatiya Nyaya Sanhita 2023. Second one, Section 17A of the PCA deals with investigation of offences related to public servants allegedly committed during the discharge of official functions or duties. Third statement, Section 17A of PCA was introduced through an amendment to PCA in 2018. So, which of the following statements is correct? So, this is related to recent case against Karnataka CM. So, what happened there? In some land scam allegations, state governor approved to investigate on CM. So, based on that one, these statements are given. Governor may sanction initiating proceedings against the CM under the Prevention of Corruption Act 1988 and the Bharatiya Nyaya Sanhita 2023. So, these is the new IPC sections. So, under which 2023 and also Prevention of Corruption Act 1988, Governor may sanction initiating proceedings against CM. Is it correct or wrong? So, this statement is correct. So, Governor has that power. Second one is Section 17A of the PCA deals with the investigation of offences related to public servants. So, PCA means Prevention of Corruption Act. So, Section 17A of the PCA deals with the investigation of offences related to public servants. Public servant means government job holders, like that. So, this is also correct statement, allegedly committed during the discharge of official functions or duties. So, 17A of PCA was introduced through an amendment to the PCA in 2018. So, this section is introduced through the amendment of PCA in 2018. So, all these statements are correct. So, next question. Consider the following statements. The number of judges in the Supreme Court can be increased by the Parliament by law. So, is this correct statement? Next statement is the number of judges in the High Courts can be increased by the respective state legislatures by law. Third one is in case of High Courts serves two or more states, the number of judges in such High Courts is increased by the Parliament. So, which of the following statements are correct? If you see the first statement, the number of judges in the Supreme Court can be increased by the Parliament by law. This is correct statement. So, at first introduction, at first in our Constitution, there is one CJI and 7 Supreme Court judges. Now, 1 CJI and 33 Supreme Court judges. So, Supreme Court judges can be increased by Parliament by producing any law. So, this statement is correct, but this second statement is wrong. The number of judges in the High Courts can be increased by the respective state legislature by law. This is wrong. The number of judges in the High Courts can be increased by President order. So, by using executive order itself, we can increase the High Court judges number. No need of state legislatures approval. So, this statement is wrong. In case of High Court serves 2 or more states. Even in this case also, by using President order, we can increase the judges in that High Court. No need of any state or parliament approval. So in case of High Courts, it may be have jurisdiction over one state or more. Both the cases, executive order by President is enough to increase the number of judges. Next question. The practice of plea bargain refers to which of the following? So plea bargain. What is plea bargain? The accused agreeing to a reduced sentence in exchange for pleading guilty. The accused demanding a full trial while negotiating for benefits. The accused pleading not guilty and facing a full trial. The court offering a complete acquittal without trial. So what is plea bargain? So plea bargain means accused agreeing to reduce sentence in exchange for pleading guilty. So accused agreeing guilty, so to reduce a sentence. So this is called plea bargain. So the accused agreeing to reduce a sentence in exchange for pleading guilty. A plea bargain involves the accused giving up their right to plead not guilty and demand a full trial, instead opting to plead guilty in exchange for a reduced sentence or other benefits. Next question. Consider the following statements with reference to the Civil Registration System, CRS. So CRS is the Union Government's centralized portal to register births and deaths. Next statement, it falls under the state list of the Constitution of India. Third one, the Registrar General of India is responsible for coordinating registration activities throughout country. So which of the following statements are correct? So if you see, first statement is correct. This civil registration system is newly introduced. So it is a centralized portal to register births and deaths. So it falls under the state list. It is wrong, because civil registration also, register of births and deaths falls under concurrent list. So that means both central government and state government can make laws in this civil registration. So it falls under the concurrent list of the Constitution of India. The Registrar General of India is responsible for coordinating registration activities throughout country. This statement is also correct. So first statement, third statement are correct, second is wrong. So statement 2 is incorrect, as CRS operates under the concurrent list, not the state list. Consider the following statements with reference to the Disaster Management Amendment Bill 2024. It proposes the creation of national and state level disaster database, including various disaster related details. Next one, the bill mandates the formation of an urban disaster management authority for all state capitals and large cities, including 8 union territories. Third one, it shifts the responsibility for disaster planning from the National Executive Committee and State Executive Committees to the National and State Disaster Management Authorities. So which of the following statements are correct regarding Disaster Management Amendment Bill 2024? It proposes the creation of national and state level disaster database. So this statement is correct. Next one is, the bill mandates the formation of urban disaster management authorities for all state capitals and all large cities, including 8 union territories. So up to this statement is correct. Up to this part, this statement is correct, but not on all 8 union territories except Delhi and Puducherry. Remaining in all other union territories, so it is mandated to form urban disaster management authorities. So next one is, it shifts the responsibility for disaster planning from the National Executive Committees and State Executive Committees to the National and State Disaster Management Authorities. This statement is correct. Before that one, there is no specific committees for this one. Now they are forming National and State Disaster Management Authorities. Next question. So the bill makes provision for the constitution of Urban Disaster Management Authority for state capitals and large cities having municipal corporations, except UTs of Delhi and Chandigarh, not Puducherry, it is Chandigarh. Next question. With reference to the subclassification of scheduled caste, which of the following statements are incorrect? So as we first already discussed, the Supreme Court agreed to divide the SCs and STs as groups, as like how OBCs are divided, BCA, BCB, like that. Now SC and STs also can be divided as SCA, SCB, like that. So it is the duty of state to divide that one. So in that classification, what are the guidelines? States are allowed to subclassify the scheduled castes for more preferential treatment in public employment and education. Is this correct statement? So this is the correct statement. Next one is, states must ensure that subclassification categories do not receive 100% reservation and must provide empirical data justifying the subclassification. So state don't have power to classify as they want, and also their classification, all classified peoples don't get 100% reservation in that SC STs. Everyone need to be get in the representation in their classifications, and also they provide empirical data to justify their classification. So it is the duty of states to divide the SC and ST into again subcategories. Next one, recent Supreme Court ruling permits states to subclassify scheduled castes but prohibits 100% reservation for any subclass and requires jurisdiction justification based on empirical data. So next question, with reference to the recusal of judges. So recusal of judges, consider the following statements. First one, as per the Judges Inquiry Act 1968, if a judge that does not recuse him or herself from a case involving conflict of interest, it can become one of the reasons for the removal of the judge in the parliament. Next statement, having a prior or personal association with a party involved in the case can be a reason for the recusal. So what is first of all recusal? The recusal of a judge means having a prior or personal association with the party involved in the case. So there is a case given to the any judge. So in that case, his families or friends or his business may be included. In that case, he himself can leave that case by saying that I have a conflict of interest in this case, so that's why I am recusal from this case. So that is called recusal of judges. So having a prior or personal association with the party involved in the case can be reason for the recusal. This is correct statement. Now see the first one, as per the Judges Inquiry Act 1968, if a judge does not recuse himself from a case involving conflict of interest, it can become one of the reasons for the removal of judges in the parliament. So this statement is incorrect. So it is not mandatory to recuse from a case. It is the judges wish to do that case, or he can recuse. So it is not mandatory. It is in discretion power. He can do that. He can do that one, or he can recuse from that case. So recusal is personal opinion of judge. It's not mandatory for the judge to not participate in cases in which he may have personal interest. So even though he has personal interest, he can do that one. So there is no mandatory to recuse himself. Next question, which of the following statements regarding judges of Supreme Court is incorrect? The senior most judge of the Supreme Court should be appointed to the office of Chief Justice of India. Second one, it is mandatory for the President to consult the Chief Justice of India during the appointment of other Supreme Court judges. Third one, Constitution has prescribed 45 years as the minimum age for appointment as a judge of the Supreme Court. Only a citizen of India is eligible to become judge of the Supreme Court. So which of the following statements are correct regarding the judges of Supreme Court? So if we see the first one, the senior most judge of the Supreme Court should be appointed to the office of the Chief Justice of India. So this statement is correct. So senior most, not by age, by service in Supreme Court. So that person need to be made as Chief Justice of India. Now see the second statement. It is mandatory for the President to consult Chief Justice of India during appointment of other Supreme Court judges. So this statement is correct. Next one, Constitution has prescribed 45 years as the minimum age for the appointment as a judge of the Supreme Court. This statement is incorrect because there is no minimum age prescription. So only retirement age is provided. 65 years is the maximum age to appoint a Supreme Court judge. So there is no minimum age. So only a citizen of India is eligible to become a judge of the Supreme Court. So this statement is correct. So C only wrong. There is no mention of minimum age. So there is no minimum age requirement to appoint the SC judge, but retirement age is 65 years. Next question, which of the following statements are correct? First one, the Constitution of India empowers the Supreme Court to entertain a petition as an appeal, even in cases where a High Court declines to issue a certificate of that appeal. So again I read this statement. The Constitution of India empowers the Supreme Court to entertain a petition as an appeal, even in cases where a High Court declines to issue a certificate for that appeal. Second one, special leave petition is a discretionary power of the Supreme Court and cannot be claimed as a matter of right. So which of the following statements are correct? So we cannot go directly to the Supreme Court to appeal any judgment given by the High Court. So High Court need to give a certificate, but it is mandatory in every case? No. In some specified cases, Supreme Court, even though High Court declines to issue a certificate for that appeal, then also Supreme Court can take that case. So this statement is empowers the Supreme Court to entertain petition as an appeal, even in cases where a High Court declines to issue a certificate for that appeal. This statement is correct. So next one is special leave petition is a discretionary power. So special leave petition is nothing but this is the case. So when there is no certificate issued by the High Court for appeal, then also Supreme Court can take. So this is the discretionary power. So no need to take any other's opinion. So Supreme Court can take discretionarily to special leave petition. So both the statements are correct. If you see the explanation, one can approach Supreme Court against HC judgment when High Court issue a certificate to go to SC. It is related to constitutional matter, related to larger public interest. In case HC overturn lower, in case HC overturn lower court order and gives you punishment more than 10 years of jail. In all these cases, we can approach Supreme Court. Even though above conditions are not met, then also SC can entertain an appeal, but it is very less chance to approve. So this is the case called special leave petition. So this is the end of today's class. Thank you very much.